Okay, let's get started. Welcome everyone, and thank you for joining us virtually this morning for what we hope will be an informative presentation for landlords and tenants in the city of Richmond. My name is Monica Bejarano, and I am the Rent Programs Administrative Aide for the Public Information Unit. Deputy Director Paige Russo will be conducting this morning's presentation. And before we get started, I would like to share some logistical information. Please note this presentation has been posted on the website at richmondrent.org/workshops for your reference. Please also note that this presentation is being recorded, and we hope to post the recording on our workshop page as well. If you have any questions on a particular topic discussed today, we ask that you type your questions into the Q&A function on the bottom of your screen, and we will address questions at the end. Without further ado, I would now like to introduce Paige Russo.
Good morning, everyone, and thank you for joining us. The topic of today's presentation is navigating the eviction process in Richmond, and we have a lot to cover, so I'm going to go ahead and get started. So before we launch into the general content, I wanted to provide an update on the moratorium that the city currently has in effect. So the Director of Emergency Services issued an order. That order is Resolution 2020, which was effective March 17th, 2020, which provides that during the period of local emergency, no landlord may terminate a residential or commercial tenancy for non-payment of rent or any no-fault just cause for eviction, such as owner move-in, withdrawal from the rental market, substantial repairs, or a temporary tenancy. These protections have been extended through September 30th of 2020. And it's important to note that the tenant must notify the landlord in writing of their inability to pay rent due to financial hardship related to COVID-19, if that's the case, and it still is responsible for paying any unpaid rent within 12 months after the order is lifted. And we have more information in a fact sheet available on the front page of our website at www.richmondrent.org. So as I mentioned, the order has been extended through September 30th, 2020, and the order also prohibits any residential rent increases for any rent-controlled property. So if a property is currently a fully covered unit under rent control, which we'll get into later, the different categories of units covered under the ordinance, then currently landlords are prohibited from issuing rent increases. Now, exceptions to the rent increase prohibition include properties that don't fall under rent control. So that includes single-family homes, condominiums, new construction built after February of 1995, and any other property whose rent cannot be regulated pursuant to state or federal law. Landlords cannot charge late fees or require documentation to prove financial hardship. And again, please access our website at www.richmondrent.org. You can access our fact sheet there, and that answers a lot of questions that we're receiving from tenants and landlords about the current city order. So with that, that was just an overview of the city's order. I want to get into the content that we're going to cover in today's presentation. So we'll talk about the purpose of the rent ordinance and a general overview. We'll discuss properties that are covered under the rent ordinance. We'll talk about compliance with enrollment, registration, and fee payment requirements, just cause for eviction, eviction noticing requirements, and the eviction process. We'll talk about no-fault evictions, the relocation ordinance, important tips on evictions in Richmond, and an overview of some important California state laws. So we have a lot to cover, so let's get started. So first, generally, the purpose of the rent ordinance, which its full name is the Richmond Fair Rent, Just Cause for Eviction, and Homeowner Protection Ordinance, is to promote neighborhood and community stability, healthy housing, and affordability for renters in the city of Richmond by controlling excessive rent increases and arbitrary evictions to the greatest extent allowable under California law while ensuring landlords a fair return. So the rent ordinance does this in two main parts. The first part of the rent ordinance is rent control. And this means that rents are regulated. The maximum allowable rent that can be charged for any rent-controlled property is calculated by taking the base rent and adding annual general adjustments, which are annual cost of living increases that the board publishes in June of each year, plus any allowable individual rent adjustments that are ordered by a hearing examiner through the petition process. So there are a few important key components that landlords and tenants need to be aware of in calculating the maximum allowable rent. And one of those is the base rent. The base rent is the rent that was in effect on July 21st, 2015, or the first rent that was charged for tenants that moved in after that date. So we take the base rent, we add all the annual general adjustments. Again, those are the annual cost of living increases. And in Richmond's ordinance, they're equivalent to 100% of the consumer price index for the Bay Area. And we add any individual rent adjustments that have been ordered through the petition process. And the petition process is a mechanism to increase or decrease the maximum allowable rent based on reasons permitted by the rent ordinance. So both landlords and tenants can utilize the petition process to request decreases or increases in the maximum allowable rent for a host of reasons. The other big part of the rent ordinance is just cause for eviction protections. What this means is that a landlord needs to have one of 8 just causes to terminate a tenancy. These 8 just causes are the failure to pay rent, breach of lease, if the tenant's creating a nuisance, or failing to give access, if the tenant needs to temporarily vacate the property so that the landlord can undertake substantial repairs. Then there are some no-fault evictions permitted by the rent ordinance. These include owner move-in or relative move-in, withdrawal from the rental market, that's pursuant to the Ellis Act, and a special just cause that's specific to Richmond known as temporary tenancy. We'll get into that, what that means later in the presentation. So which properties are covered by the rent ordinance? So there's 3 general categories of units covered in some way by the rent ordinance. The first are fully covered units. These are also called controlled rental units. This means that both rent control and just cause for eviction protections apply. These units include multi-unit properties built on or before February 1st, 1995. So anything from a duplex on up that was built before February 1st, 1995 is fully covered, meaning that both rent control and just cause for eviction protections apply. Then there are some units that are partially covered, meaning that only just cause for eviction protections apply. These units are not rent controlled, but a landlord does need to have one of the 8 just causes to terminate a tenancy. These include subsidized units, including Section 8 tenancies, properties with 1 dwelling unit on 1 parcel, condominiums, and new construction constructed after February 1st of 1995. And we always like to make clear that new construction, this is an exemption that's provided by the California state law known as the Costa-Hawkins Rental Housing Act. And this requires that the units are permitted with a certificate of occupancy to be considered new construction. In the city of Richmond, that means that the permits have been finalized and the unit is fit for residential habitation. So unpermitted units, even if they were built after February 1st of 1995, would not qualify as new construction. And then there are some properties that are fully exempt, which means that there's no rent control and no just cause for eviction protections, and the rent ordinance largely does not apply. These include tenancies where the landlord and tenant share a kitchen and/or bath, single-family homes where a permitted accessory dwelling unit or ADU was added and the main house is owner-occupied, as well as retirement homes. So these are the 3 categories of units that are covered or exempted from the rent ordinance. So I want to talk a little bit about compliance with the just cause for eviction requirements. And so we're going to talk about just cause for eviction in more detail. We'll talk about the eviction noticing requirements and generally the eviction process. So just cause for eviction, as articulated in RMC 11.100.050. So this section of the rent ordinance provides that residential tenants can only be evicted for one of the following just causes for eviction, and the notice must state the reason for eviction. Oh, sorry about that. Go back. So the first just cause is failure to pay rent after having been served a 3-day notice to pay rent or quit. Breach of lease. So if the tenant continues to violate the lease after being warned in writing to cease the violations. Nuisance. If a tenant continues to cause a nuisance after being warned in writing to cease causing the nuisance. If the tenant fails to give access to the unit, and that is if the tenant continues to deny a landlord lawful entry per Civil Code 1954 after receiving written notice to cease denying lawful entry. If the tenant needs to temporarily vacate in order to undertake substantial repairs. If the owner or a relative of the owner would like to move into the property. If the owner wishes to withdraw the unit from the rental market pursuant to the Ellis Act. And a temporary tenancy. So there are a couple important things to note here. You'll notice that for breach of lease, nuisance, and failure to give access, the landlord must warn the tenant in writing of the violation before they can actually move forward with terminating the tenancy. And we have a template available on our website that landlords can use to notify tenants of these violations. For the tenant needing to temporarily vacate in order to undertake substantial repairs, for owner move-in, and for withdrawal from the rental market, the landlord must provide a relocation payment. And that was provided in the relocation ordinance that was established by the City Council in 2016. So as I mentioned previously, for the breach of lease, nuisance, and failure to give access just causes for eviction, landlords must provide a written warning notice prior to moving forward with terminating a tenancy. And the rent ordinance has specific requirements that need to be in the written warning notice. So first, the written warning notice must be served prior to a notice of termination of tenancy if the just cause is breach of lease, nuisance, or failure to give access. The written warning notice must provide the tenant with a reasonable period of no less than 5 days to correct the violation prior to serving a notice to terminate tenancy. The notice must state that a failure to cure the problem may result in their eviction. It must inform the tenant of their right to request a reasonable accommodation. The written warning notice needs to include the contact number of the rent program. It needs to include some instructions for how the tenant can comply. So let's say the tenant has a pet when the lease states that they cannot have pets. The written warning notice needs to describe what they would need to do to comply. So in that case, it would mean most likely getting rid of the pet. And it shall include necessary information to determine the date, time, place, witnesses present, and other circumstances that led the landlord to issue the written warning notice. And again, we do have a template available on our website for landlords to use or reference. Our template includes all of these requirements. So I want to also go over the noticing requirements that are provided by the rent ordinance specific to just cause for eviction termination notices. So the rent ordinance requires that landlords submit a copy of any termination of tenancy notice that was served on a tenant within 2 business days of serving the tenant, along with a proof of service. The termination of tenancy notice should be submitted online. So we have an online portal where landlords can upload the notices. And for properties with 5 or fewer units, the landlord may submit the notice by mail, so mailing it to the rent program. It's important to note here that the failure to file the termination notice in a timely manner may be asserted by the tenant as an affirmative defense in an unlawful detainer or eviction proceeding. So in other words, the enforcement mechanism of this requirement is that if the landlord fails to file the termination notice with the rent program, the tenant can raise that as a defense if they're in an eviction lawsuit. So in our office, we receive a lot of questions about the just causes for eviction. And so it's important to reiterate what are not just causes in Richmond. So again, there are 8 just causes to terminate a tenancy in the city of Richmond. And we hear a lot about questions about if certain circumstances qualify as just cause. So we wanted to provide some examples of circumstances that are not just cause to terminate a tenancy in Richmond. So first, the mere expiration of a lease agreement. So especially where the contract says that the tenant must move at the end of the lease, that is not just cause in the city of Richmond. So just because a lease terminates does not mean that the tenant needs to necessarily vacate. It does not mean that the landlord has a just cause to evict. The lease would then transfer to a month-to-month agreement in most circumstances. The sale, transfer, or foreclosure of the property is not just cause. So we see many tenants and landlords come in saying, you know, I'm selling my home, I'm selling my duplex or my single family home. How do I evict the tenant? And that is not the mere sale, transfer, or foreclosure of the property is not a just cause provided in the rent ordinance. So the landlord would need to either, you know, use one of the other no-fault just causes and provide the relocation payment, or sell the property with the tenant remaining in possession of the unit. The tenant is paying below market rent, and the landlord wants to evict the tenant to be able to reset the rent to market rate. That is not a just cause in the city of Richmond. If the landlord makes a unilateral change to the terms of a tenancy, and the tenant violates that unilaterally imposed term, that is not just cause. So this is, for example, a situation where the tenant and landlord have already entered into a lease agreement, and the landlord, after the tenancy has already commenced, is making a unilateral change. So it's not something that the tenant is agreeing to. It's a unilateral change in the term of a tenancy. If the tenant violates that unilaterally imposed term, that is not just cause to evict in the city of Richmond. Or if the landlord unreasonably denies a replacement roommate, so one-for-one replacement, and then tries to evict for subletting or subleasing, that is not just cause in the city of Richmond. Tenants are generally permitted to replace roommates on a one-for-one replacement basis. The landlord does have an opportunity to accept or reject that replacement, but if the landlord unreasonably denies a replacement roommate and then tries to evict for subletting or subleasing, that is not just cause in the city of Richmond. So this is a slightly overwhelming chart, but I did want to walk through generally what the eviction process would look like for tenants in the city of Richmond. Now, I do want to note that currently there is the eviction moratorium in place. So through September 30th of this year, this process does not currently apply unless, you know, of course, if the tenant has met their requirements in terms of notifying the landlord in writing of the financial hardship caused by COVID. So let's just walk through this scenario. So if the tenant fails to pay rent, the landlord would serve a 3-day notice to pay rent or quit. And then the landlord must file a copy of that notice with the rent program within 2 business days after serving the tenant. And failure to do so may result in an eviction lawsuit. If the tenant fails to pay rent within the 3 days that they've been given, the landlord can file an eviction lawsuit with the courts. Now, the tenant must respond to that eviction lawsuit with their affirmative defenses within 5 days of having been served the lawsuit. And at this point, the flowchart breaks into a first alternative and a second alternative. So if the tenant does respond with their affirmative defenses within the 5-day deadline, then the court will mail a notice of hearing or trial date. A judge or jury trial will be held, and one of 3 things could happen. 1, the tenant could win and is able to remain in the unit. the tenant and landlord could agree to a settlement that has specific terms that they would agree to, or the landlord wins and is awarded possession of the unit. Now, if the landlord wins and the tenant does not move out of the unit voluntarily, the landlord would need to go back to the court and ask them to issue a writ of possession. The sheriff would then serve the tenant with a 5-day notice to vacate. Now, if the tenant receives that notice from the sheriff and does not move, then the tenant will be escorted by the sheriff from the property and is not allowed to return. So that's the first alternative. You'll see the process is much longer and the tenant has more time if they respond with their affirmative defenses within the 5-day deadline. Now, a second alternative is the tenant fails to respond within the 5-day deadline. And if that happens, the landlord can then file a request for default judgment. And if that's approved, the default judgment is entered against the tenant. So in other words, if the tenant did not respond, the landlord files for the default judgment, in which the landlord wins by default. And if approved, that default judgment is entered against the tenant. If the tenant does not move voluntarily, the landlord would ask the court to issue a writ of possession, and the sheriff serves the tenant with that 5-day notice to vacate. If the tenant does not move voluntarily within that 5 days, the sheriff would evict the tenant. The tenant is escorted from the property and may not return. So let's look further at no-fault evictions. So we're going to provide some information on the owner move-in and withdrawal from the rental market just causes for eviction. So again, we call these no-fault evictions because the tenant has not committed something wrong. They're up to date with their rent, they haven't violated their lease agreement, they haven't caused a nuisance or failed to give access, but the landlord still has some just causes where the tenant is not at fault. And those include owner move-in and withdrawal from the rental market. So eviction for owner or relative move-in takes place when the owner wants to recover possession of the rental unit as their primary residence for the owner or the owner's spouse, children, parents, or grandparents. So again, relative move-in is not a catch-all for any type of relative. The rent ordinance specifies that it is for the owner or the owner's spouse, children, parents, or grandparents. Now, it's important to note that an owner in this section is considered an actual person who has at least a 50% recorded ownership in the property. An eviction for owner move-in cannot occur if the same owner or chosen relative already lives in a unit on that property, or if there's already a vacant unit on the property. But the rent ordinance does specify that at all times, an owner can request a reasonable accommodation if the owner or chosen relative is disabled and another unit is necessary to accommodate the person's disability. It's important to note that tenants have a first right of refusal to return to that unit if the unit is placed back on the rental market. So in terms of noticing requirements for owner move-in, the tenant must be served with an owner move-in notice for termination of tenancy. Usually, the owner move-in forms may be downloaded from our website, but due to the emergency order that prohibits no-fault evictions at this time, we request that you contact us to have those forms emailed to you. So you can reach out to a rent program counselor by calling 510-234-RENT, and we'll have a conversation with you and send you those forms if it's deemed that that is the route that you want to take after the order expires. The owner must give the tenant at least a 60-day written termination notice if the tenancy has been in place for more than a year. And again, within 2 business days after serving the tenant with a termination of tenancy notice, the landlord must file a copy of the notice with the rent board with a completed proof of service. Failure to do so renders the notice of termination null and void, and again, can be raised by the tenant as a defense in an unlawful detainer lawsuit. So I want to go over a couple requirements of the owner move-in process because this is a very specific process and the ordinance spells out specific requirements that landlords need to follow when they choose to move forward with an owner move-in eviction. So the person moving into the unit, be that the owner or a relative of the owner, shall move into the rental unit within 90 days after the tenant vacates and must occupy the unit as a primary residence for at least 36 consecutive months. The owner must pay 1/2 of the applicable relocation payment amount, and we'll get into what those amounts are in just a moment, within 3 business days after the tenant has informed the owner in writing when the tenant plans to vacate the unit. The remaining half of the relocation payment is due within 3 business days after the tenant has vacated the unit. If the owner or the chosen relative fails to occupy the unit within 90 days after the tenant vacates, the owner shall do one of 2 things. Actually, they need to do both of these things. They need to first offer the unit to the tenant who vacated it and pay the tenant all reasonable expenses incurred in moving to and from the unit. So that's if the owner or the relative fails to occupy the unit within 90 days. Now, in rent-controlled properties, so again, these are multi-unit properties built before February 1st, 1995, if the tenant moves back to the property, the owner may be eligible to apply the applicable annual general adjustment or AGA rent increases. The landlord must provide the tenant with proper noticing requirements for rent increases. So let me explain. In rent-controlled properties, if the tenant moves back into the unit, the rent, per the rent ordinance, needs to go back to the rent that they were paying when they were evicted. However, the landlord may be eligible to apply all the annual general adjustment rent increases that took place while the tenant wasn't in the unit. Now, for non-rent controlled properties, if the tenant moves back to the property, the landlord may apply rent increases. Because it's not a rent-controlled property, landlords are not restricted to AGA rent increases. But still, landlords must provide tenants with proper noticing requirements for rent increases provided by state law. So I just want to also mention some protections for disabled or senior persons from owner move-in evictions. So the rent ordinance provides that an owner may not evict through owner move-in if the tenant meets the following criteria. 1, the tenant has to have resided in the rental unit for at least 5 years, and if the tenant is at least 62 years old, disabled, or is certified as being terminally ill by the tenant's treating physician, then the landlord cannot move forward with completing an owner move-in eviction. However, an owner may evict a tenant who's protected if the owner or chosen relative also meets the same criteria and no other units are available. So let's say the owner is at least 62 years old, they're disabled, or is certified as being terminally ill, then the rent ordinance says that they can move forward with an owner move-in eviction. So that was specific to the owner move-in just cause provided by the rent ordinance. I now want to move on to another no-fault eviction that's permitted by the rent ordinance, and that's called the Ellis Act, or withdrawal from the rental market. So the Ellis Act is a California law contained in Government Code Section 760 that provides landlords in California with a legal way to go out of the rental market business. The Ellis Act was adopted by the California legislature in 1985 after the California Supreme Court decision in the case of Nash versus City of Santa Monica. And we have a lot of information on our website about the Ellis Act and the detailed steps that a landlord needs to follow to successfully conduct an Ellis Act eviction on our website. So let's talk about notice requirements for withdrawing a unit from the rental market. First, the tenant must be served a written notice for withdrawal from the rental market that terminates the tenancy. The owner must give the tenants no less than 120 days for the tenants to vacate the property if there is not a qualifying tenant who lives in the household. Qualified tenants, which I'll explain in just a moment, are allowed more time to vacate. The owner shall provide a written notice to each tenant on the property, notifying them of the withdrawal from the rental market. This is another important requirement I want to highlight. A landlord cannot withdraw only one unit from a property. If they're going to move forward with withdrawal from the rental market, they need to withdraw all units from the property, from the rental market. So for example, if an owner owns a triplex, they cannot do a withdrawal from the rental market for just one of those units. They would need to withdraw all 3 units from the rental market. Tenants shall be entitled to a 120-day notice of termination of tenancy unless they're qualified tenants. Qualified tenants are entitled to 1 year's notice, and qualified tenants include seniors, folks with a disability, if they have at least one dependent minor child, or are considered low income and have been residing in the unit for at least 1 year prior to the date of delivery of the notice of intent to withdraw to the board. So as I mentioned previously, on our website, we list all the requirements that are necessary for completing a withdrawal from the rental market eviction. And that includes filing several notices with the rent program, including an initial notice of intent to withdraw. So we highly recommend that you contact a counselor to speak with them about this process before you initiate it, to make sure that you're following all the steps in the correct order. Now, if the qualified tenant wants the 1 year entitlement, within 60 days of the date of delivery of the termination notice to the rent program, the qualified tenant must return to the owner a notice of entitlement to a 1 year's notice. So the landlord's not required to know if the tenant is a qualified tenant or not. But the notices that are required to be served, which are on our website, clearly specify and notify the tenant that if they meet the qualifications to be a qualified tenant, they can notify the landlord that they would like 1 year's time to vacate instead of 120 days. So it is ultimately the tenant's responsibility to notify the landlord that they would like to exercise their 1 year notice option. So there are also, just like owner move-in, there are some very specific requirements that apply to withdrawing units from the rental market. So I want to spend some time talking about what happens if withdrawn units are ever returned to the rental market. So for rent-controlled properties that are being withdrawn from the market and are rented again after being withdrawn, the following applies. If the property is offered for rent within 2 years from withdrawing the unit from the rental market, the owner shall, 1, be liable for the actual and punitive damages to the tenant who was displaced by the property being withdrawn, and 2, the unit must be offered back to the tenant who was displaced. So the Ellis Act has certain requirements that apply for 2, 5, and 10 years. So depending on how soon after being withdrawn the unit's offered for rent again, different requirements apply. So that's what happens if the unit is offered for rent within 2 years after withdrawal. Now, for the first 5 years after withdrawing the unit, if the property is reoffered for rent, the property shall be offered back to the vacating tenant at the rent in effect when the property was removed from the rental market. An annual general adjustment rent increase may be applied if the tenant moves back. So if several years have elapsed since the tenant lived in the unit and the unit is re-rented and offered back to that tenant who vacated, the landlord may be able to apply annual general adjustment rent increases. If the property is demolished, reconstructed, and offered for rent within 5 years from the withdrawal of the market, the newly constructed units shall be subject to rent control. If the property is offered for rent within 10 years from withdrawing from the rental market, the owner shall notify the rent board and offer the unit back to the tenant who was evicted. And so just like the owner move-in eviction process, the same goes for withdrawal from the rental market, in that tenants have a first right of refusal to return to the unit if it's ever placed back on the market. Okay, so those are the no-fault just causes for evictions. I now want to talk about the Richmond Relocation Ordinance. And this was adopted by the City Council in 2016. So the Relocation Ordinance specifies different types of relocation payments. There's temporary relocation payment and there's a permanent relocation payment. Now the temporary relocation payment applies when the tenant must temporarily vacate for the landlord to undertake substantial repairs, or if there is a governmental order to vacate, or such as a red tag or yellow tag issued where the tenant has to move out, or if the tenant is forced to vacate due to other conditions that are a threat to health or safety. The notice of entitlement to temporary relocation payment must be provided with the notice of termination of tenancy. So when the landlord files that termination notice to the tenant saying that they must temporarily vacate, they must also provide the notice of entitlement to temporary relocation payment. And we have a template of that available on our website as well. The relocation payment amount is determined by a resolution of the City Council. So the relocation payment amounts are updated each year. So these are the amounts that are in effect for 2020, and these are per diem or per day expenses. So the relocation ordinance provides that if a tenant is temporarily displaced, the landlord will pay them $161 per day per household for a hotel or motel, $32 per day per person for meal expenses, $1 per day per household for laundry. And if the landlord has allowed the tenant to have pets, then the landlord shall pay $31 for cats per day per animal and $56 per day per animal for dogs. Applicable amounts shall be paid on a weekly basis and calculated on a daily basis at a minimum. Alternatively, the landlord may provide comparable housing located in Richmond, and in such case, the landlord shall provide per diem payments until the tenant and their possessions have been moved into the comparable rental unit. Okay, so that covers temporary relocation payment. Now, in terms of the permanent relocation payment, the permanent relocation payment is required for tenants who are whose tenancy is terminated due to owner move-in or withdrawal from the rental market, or under other extenuating circumstances due to governmental order to vacate or health and safety conditions. So just like with the temporary relocation payment, if a landlord is moving forward with evicting a tenant for owner move-in or withdrawal from the rental market, the landlord must provide notice of entitlement to relocation payment with the notice of termination of tenancy. And again, that notice is available on our website. And as with temporary relocation payments, the amount of the permanent relocation payment is determined by a resolution of the Richmond City Council. So these are the amounts that were adopted in they were updated for 2020. For owner move-in, the maximum cap per unit type for a studio is $3,774. For a one bedroom is $5,826, and for a 2+ bedroom unit is $7,934. Now, a qualified tenant household amount is slightly higher, and folks that are considered qualified tenants are any household that includes at least one tenant that is a senior citizen, disabled, or has at least one minor dependent child, as defined in the relocation ordinance. Now, the withdrawal from the rental market amounts are close to double the amount for owner move-in, and the base amount for a studio is $7,602, for a 1-bedroom is $11,653, and for a 2+ bedroom is $15,814. And again, there's the higher amount for qualified tenant households. If the rental unit is occupied by one tenant, then the entire per unit relocation payment shall be paid to that tenant. If more than one tenant occupies the rental unit, then the total amount of the relocation payments shall be paid on a pro rata share to each eligible tenants. The relocation payments are calculated on a rental unit basis, distributed on a per tenant basis, and includes a maximum cap per rental unit. And again, a qualified tenant household is any household that includes at least one tenant that's a senior citizen, disabled, or has at least one minor dependent child, as defined in the rent ordinance, in the relocation ordinance. Okay, so now that we've covered the basics, I wanted to share some important tips on eviction in Richmond. So a self-help eviction is when a landlord attempts to lock a tenant out, cuts off the utilities, or otherwise takes their own action to terminate the tenancy without going to court. And it's important to note here that self-help evictions are illegal in California. A landlord must proceed with the unlawful detainer or eviction lawsuit process and receive a judgment from the court in order to evict a tenant. If the tenant does not vacate, the sheriff evicts the tenant with a writ or judgment in their possession. So it's important to note that the sheriff is really the only one who is authorized to actually evict a tenant, and self-help evictions are illegal. It's also important to note that evictions can be highly technical. So if a landlord is considering going through, or a tenant is going through the eviction process, they should consider speaking to legal counsel to better understand the process and possibly have the attorney represent them in court. It would be in both tenant and landlord's best interest to educate themselves about their responsibilities and rights under the rent ordinance and California law. And no-fault evictions, such as owner move-in and withdrawal from the rental market, they're complicated. As I just went over a bunch of content that includes a lot of specific requirements, processes, and payments. So there's a lot to them. They're complex, and they require special noticing, permanent relocation payments, and provide special rights to the tenant, such as the right to move back in at the rent paid when the tenant vacated, and the protected status for qualified long-term tenants. So that said, really in both the tenant and landlord's best interest to educate themselves about their rights and responsibilities under the rent ordinance by attending these workshops, by contacting our office to speak with a counselor, and accessing resources that are available on our website. Take evictions seriously. As I mentioned, contact the rent program as soon as possible. If you're a tenant and you receive threats of eviction, warning notices, or actual termination notices, such as a 3-day notice to pay rent or quit, or a 60-day termination notice, or court documents for an unlawful detainer. If you're a landlord, contact the rent program if you're considering issuing any of these notices or documents. It can save you a lot of time because, as I'll get into next, the eviction process has firm deadlines, which if not met can lead to the tenant being evicted. So if an unlawful detainer complaint or eviction lawsuit is received, tenants generally only have 5 days to respond with an answer to the unlawful detainer. If a tenant does not file the answer to the unlawful detainer with the court within the allowed time, the judge may enter a default judgment against the tenant. And likewise, there are very strict requirements that landlords need to follow. So as I mentioned first, contacting the rent program is incredibly important if you're a landlord or a tenant to make sure that you understand the requirements so that you don't have to, if you're a landlord, restart the process all over again because there was a mistake made in the beginning, or if you're a tenant, you find that you're receiving notices of eviction from the sheriff's office because you weren't aware that you needed to respond to the judgment within, or to the unlawful detainer complaint within 5 days. So really important to stay on reach out. Be a tenant in good standing. So prior to just cause eviction protections in Richmond, tenants could be evicted without a just cause. Tenants should avoid giving the landlord a just cause reason to evict by being mindful not to violate the lease, cause a nuisance, deny lawful landlord entry, or otherwise damage the property. So before we close the presentation and go on to the question and answer period, I wanted to go over some important California state laws. So first, proper notice when terminating tenancy. So for no-fault evictions, the landlord must give at least 30 days written notice to terminate a tenancy if the tenancy is less than 1 year. A landlord must give at least 60 days written notice to terminate a tenancy if the tenancy has lasted 1 year or more. Under Civil Code 1946, a tenant can give a 30-day written notice to vacate, in other words, terminate their tenancy, and can give notice on any day of the month once the lease has converted to a month-to-month lease. And I'll just note that any termination notice served in the City of Richmond must cite one of the permitted just causes for eviction, unless the rental unit is fully exempt from the rent ordinance. So I want to just share Civil Code 1954, which talks about landlord lawful entry. So the landlord, this is provided in the California Civil Code. Again, this is state law that provides that landlords can only enter to make necessary or agreed upon repairs, decorations, alterations, or improvements, supply necessary or agreed upon services, or exhibit the dwelling unit to prospective or actual purchasers, mortgagees, tenants, workers, or contractors, or to make an inspection pursuant to Civil Code Section 1950.5, which is a security deposit law. The landlord must give the tenant written notice to enter at least 24 hours prior to entry. But the landlord does not need to provide written or verbal notice to enter in cases of emergency. So if there's a fire or flooding, that's an exception. The landlord does not need to provide written notice. The tenant cannot demand that they be there when the landlord enters. So this is a common question we get from tenants. They say, my landlord just gave me notice that they're coming into my unit. Can I say no because I'm not going to be home? And the answer is that that can put them at risk because, again, failure to give access to the unit is a just cause for eviction in Richmond. And the tenant cannot demand that they be there when the landlord enters the unit. That said, entry by the landlord must be during normal business hours. The landlord must state the time and the date, as well as the purpose of the entry in the written notice. And just again, as a reminder, in Richmond, it is a just cause to evict a tenant who denies a landlord lawful entry after the tenant has been warned to cease denying lawful entry access and continues to do so. Okay, so now I'm going to go over security deposit law. And this is contained in California Civil Code Section 1950.5. So 1950.5, first, it defines security deposits, which are any payment, fee, deposit, or charge, which is imposed at the beginning of the tenancy as an advance payment of the rent, or to be used for recovering rent defaults, repairing damages caused by the tenant, or cleaning. Now, this does not include an application or screening fee. The first month's rent is not considered a security deposit, but any money paid in excess of the first month's rent, including what is called last month's rent, is considered part of the deposit. So a common question that we receive is, how much can a landlord collect for a security deposit? And California Civil Code 1950.5 provides that a security deposit may not exceed 2 times the monthly rent for an unfurnished unit or 3 times the monthly rent for a furnished unit. What can a landlord deduct from the security deposit? Well, a landlord may deduct from a tenant's security deposit only the amount that is reasonably necessary to 1, cover any rent defaults, so rent that was not paid, 2, repair damages that a tenant or a tenant's guest caused other than normal wear and tear, 3, complete necessary cleaning, defined as the amount of cleaning needed to return the unit to the same level of cleanliness as it was offered at the beginning of the tenancy, and 4, if allowed by the lease, cover the cost of restoring or replacing personal property, including keys or furniture, excluding ordinary wear and tear. It's important to note that landlords are obligated to offer a walkthrough inspection at the end of the tenancy. So tenants have a right to a walkthrough inspection no earlier than 2 weeks prior to the tenant vacating. The landlord must give 48 hours prior written notice of the inspection, unless the tenant waives this requirement in writing. The purpose of the inspection is to identify needed cleaning for the tenant to perform before moving out, so as to avoid deductions from the security deposit. And immediately after the inspection, the landlord must provide an itemized list of repairs and cleaning that need to be done to avoid authorized deductions. The landlord may still deduct for cleaning or repairs that were not identified during the inspection because they were concealed by the tenant's belongings. So if the landlord and tenant do a walkthrough inspection before the tenant moves out, and then after the landlord finds additional damage or necessary cleaning that they couldn't anticipate during the time of the inspection because the tenant hadn't moved all of their belongings, then that is, the landlord may deduct for cleaning and repairs that they hadn't identified before. When does the security deposit have to be returned to the tenants? So within 21 days after the tenant or tenants leave the unit vacant, the landlord must, 1, furnish the tenant with a written statement itemizing the amount of and purpose for any deductions from the security deposit, and 2, return any remaining portion of the deposit to the tenant. Now, where several roommates live together and have paid a deposit, the landlord is not required to return the deposit until the unit is returned to the landlord vacant. There is also a requirement to provide an itemized statement of the landlord's charges along with receipts. So if more than $125 is deducted from the deposit for cleaning and repairs combined, the landlord must attach to the itemized statement copies of documents showing the landlord's charges and costs to clean and repair the unit. So this is a common occurrence in our security deposit petitions that we see. So under the rent ordinance, tenants can petition the rent board if the landlord fails to return the security deposit. And what we'll commonly see is that the landlord may have, reason to deduct payments from the security deposit. However, if they fail to maintain itemized statement of copies of documents showing those charges and costs, then the case can be held in favor of the tenant if the landlord doesn't have that supporting documentation. So it's very important to hold on to that documentation. Now, what is the effect of the sale of the property on a deposit? A landlord who sells a rental property must either 1, transfer the deposit to the new landlord, or 2, return the deposit to the tenant. Now, what is the tenant's recourse if the deposit is not returned within 21 days of vacating? A tenant who does not receive the refund and accounting, if there were any deductions, over $125 within 21 days, or if they dispute the amount that was claimed by the landlord, they may sue the landlord for the disputed amount in small claims court if the amount is less than $10,000, and up to twice the amount of the deposit for what's called bad faith retention, which is the unreasonable refusal to return any security deposit. In court, the landlord has to prove that the amounts that they retained were reasonable. So with that, that was the last important California Civil Code that I wanted to share with you all, and that concludes the content of this presentation. But we have plenty of time for a Q&A session, and I already see that there are some questions in our Q&A box. So with that, I'd like to turn it over to you all to answer your questions. And Monica is going to assist in reading off some of the question and answers. And we also have Staff Attorney Palomar Sanchez with us this morning, and he is here to assist with some of the questions. So with that, Monica, we can go ahead and get started.
Hey, everybody.
All right. Okay, so the first question we have here, are the response to eviction deadlines based on regular days or business days?
I can answer that, Paige. So the court papers, usually the complaints say that response times only include normal days, and it does not include weekends or holidays. So basically business days.
Okay, great. And the next question is an email from the landlord considered a written notice in the case of request to entry for repair?
That's a good question. And Palomar, you should feel free to chime in. It's my understanding that if there is an email that the landlord needs to communicate in the way that they would typically communicate with the tenant. So if the tenant has only ever been provided written notices on their door or in the mail, and that's how the landlord and tenant have typically communicated, then it's probably best that that notice be provided, on their door or in the mail. But if the landlord and tenant have commonly communicated via email is probably okay. It can be very context specific.
Yeah, I agree with what Paige said. And generally speaking, judges tend to, view email as a written notice. However, she's right that if the tenant has never received an email from you, even if you get that email correct, I think there's an argument there that, they can say, well, I didn't, you've never communicated with me like that. I didn't know that you had sent me, basically. But if there is that kind of communication back and forth, that history of like communication through email, then I think it's very hard to argue that they didn't receive it. So.
Okay, great. We have some more questions that popped up. First question is, my tenant owes 6 months in rent. What if they decide to move out without paying rent?
If the tenant owes 6 months in rent and decides to move out without paying the rent, then Palomar, again, feel free to chime in. It's my understanding that the landlord would have to seek to receive those payments through the small claims court process.
Yeah, that's correct. And I apologize, I'm trying to turn on my video, but it's not turning on for some reason. In any event, yeah, that's correct. I mean, since there's a contract pursuant to the lease, the lease is a contract and there's a debt owed, then if the claim is under $10,000, then yes, the landlord can go to small claims court. If it's above $10,000, then they have to go to superior court. But, it is a debt. It would take a little bit of work, but, you would be able to likely recover that if you file something in court.
Okay, next question. Question is, do you have information on the unlawful detainer process?
So this is a good question. And Monica, I see a couple questions before that one. There was one at 10:08, 10:19, and 10:25. One of them, the first question asked also, are you discussing the unlawful detainer process? And the information that we provided on the unlawful detainer process is in that flow chart that I shared. So I can show that again. So we walked through one example where the tenant did not pay rent, and this is the flow chart of what happens. And so the landlord's recourse when a tenant doesn't pay rent, or where the landlord has just cause for eviction and the landlord does not vacate voluntarily, or the tenant does not vacate voluntarily, the landlord would need to go to Superior Court to file a unlawful detainer eviction. And if that's granted, then again, the landlord will gain possession of the unit. But of course, the tenant could also win and remain in the unit, or the landlord and tenant could agree to settle, but that's all in the court. So the rent ordinance has certain requirements about noticing and establishes the substantive grounds for an eviction. But in terms of the process to evict, that all happens in Superior Court through the unlawful detainer process.
Yeah, that's correct. And this flow chart is a somewhat simplified version of how these things work. I mean, you know, these lawsuits can get very complicated. And should you consider this, I mean, it's always highly recommended to speak to legal counsel, especially now given the current environment, right? Because of COVID and all the shutdowns, the courts have been, you know, kind of pressed to have the same amount of people come in. So there are rules now. They are, you know, processing evictions. The Contra Costa County Courts has been open since May 26th. But given the kind of added difficulty of these things with the whole pandemic going on, it's just even more emphasized to speak to legal counsel should you consider one of these actions.
Okay, and Paige, you mentioned that there are other questions. I don't see the previous questions from 10 o'clock.
Oh, okay. I can go through them then. There's one from 1019 that says, if I had a lease term of 18 months, so 1.5 years, is the landlord allowed to increase the rent by 1.5 times the allowed rate at the end of the term? So the way that the annual general adjustment, it's a little different. So each year, the rent board announces what the annual general adjustment amount is, and that can be applied September 1st of that year. However, if the landlord has entered into a year-long lease or a 2-year lease or 18-month lease, they, in most cases, won't be able to apply that rent increase until the lease expires and reverts to a month-to-month lease, unless the lease specifically allows for rent increases during the term of the lease. So if you have a lease term of 18 months and your lease doesn't state that the rent can be increased during the term of the lease, then you probably need to wait until that lease expires, and then you can see, you know, which annual general adjustments can be applied. And we do have a maximum allowable rent calculator available on our website, because it does depend on when the tenant moved into the unit, and you know, how much time has elapsed and what the amount is. So I would say once that lease expires, go onto our website, look at the maximum allowable rent calculator, or give our office a call and we can walk you through how to calculate how much you can increase the rent. And there was another question here from 1025. Monica, I'm not sure if you see this one.
No, I just see from 11 o'clock and on.
Okay, great. So this next one is, how do you evict a tenant if the tenant was behind on their rent in March 2020 before the moratorium began? They have not given written notice of loss of job as the owner has requested. The tenant has placed locks on the bedroom doors and started subleasing the rooms. Palomar, do you have thoughts about that?
Sure. Yeah, I mean, I think the question said that the tenant did not inform the landlord in writing of their financial harm due to COVID. You know, if they don't invoke those protections, then they can use the order to insulate themselves from receiving a termination notice pursuant to a non-payment of rent. So in theory, you could move forward with an eviction that, you know, it was due in March, and then this order happened, and And let's just assume for a second that, currently the order is set to expire on September 30th, but let's just say for a second it expires on that day. Then after that, you could, move forward. Plus, the thing is that for basically almost the entirety of this pandemic, the Judicial Council has had some augmented rules regarding, processing unlawful detainers. And specifically, they said, well, we're not even going to issue summons for any unlawful detainer unless the eviction is to secure the public health and safety. Now, that was the kind of rule for all of these months. But about 2 weeks ago, the Judicial Council voted to change that. And so now, at the end of September 1st, so starting September 2nd, you no longer need a public health and safety requirement for the court to move forward with your eviction. Now, Richmond we still have our order that's still in place till September 30th, but in this fact pattern, if the tenant has not claimed or has not informed the landlord in writing of their financial hardship, then in theory, yeah, you could move forward with that non-payment of rent eviction.
Was that the last question from 10 o'clock page?
Yes, the next question I see is from 1101.
Okay, I see that one. Okay, so that question is, when is the next time we can raise rent? Does the city, hold on a second. I'm not sure what the second question is asking, but we'll answer the first one. When is the next time we can raise rent?
So typically, landlords are able to raise the rent effective September 1 of each year. So the rent board announces what the annual general adjustment is in June, no later than June 30th, and then the rent can be raised September 1st. Now this year, because of the pandemic, it's a little complicated because there's currently the moratorium in effect on rent increases for rent-controlled units. So if you do have a rent-controlled property, you need to wait until the moratorium has been lifted. At this point, that looks like it's going to be after September 30th of 2020, but we don't know if that's going to be extended.
The next question is, I had already started the owner move-in process and the tenant was supposed to be out by April 25th, but the COVID stopped that. So my next step is the unlawful detainer process, correct?
I'm sorry, could you repeat that one more time, Monica?
Sure. I had already started the owner move-in process and the tenant was supposed to be out by April 25th, but the COVID stopped that. So my next step is the unlawful detainer process, correct?
Right, that would be correct. I mean, I don't know the basis of this eviction, right? I mean, it has to comply with the order. Certain types of evictions are prohibited currently, but let's just say for a second that, it was maybe a breach of lease, or something like that. That's not necessarily prohibited by the order. And if the notice has expired, then yeah, in theory, you could move forward. However, if it's something else, like for example, an owner move-in, then no, you can't do anything yet because really you're not even supposed to issue a termination notice during this time pursuant to an owner move-in or an Ellis Act. So it really does depend on, what the basis is and also kind of what you've done in terms of like preparing for the in terms of notice. Have you uploaded to our website? All of these things, which, it does kind of add up in terms of, making the process a bit more complicated. So again, emphasizing the need to speak to legal counsel to ensure that, your case moves forward in the way that you want it to. And I'm sorry, I can't turn on my video again. I'm trying. Oh, okay. Oh. There we go.
There you are. Okay, so the next question is, one of my tenants passed away due to COVID-19. Can I, the landlord, ask other tenants in the same unit if they are COVID-free? There's the second part. Does the landlord have anything, does the landlord have any responsibilities such as sanitizing the unit?
That's a good question. I mean, I think cleaning the unit is probably just good protocol, especially since you know that someone had COVID. In terms of asking the other tenants, that's a bit more complicated. Private medical information is private. People do not have to disclose their private medical information if they don't want to. And so, I think I would be cautious on how you approach that, right? If you ask, they're under no obligation to tell you. But at the same time, I understand the reason. It's like you don't want it to kind of continue to spread, and which makes sense. I mean, this is a public health issue. But that said, the requirements, or the laws regarding medical information are pretty strong. And so, you cannot force them to tell you private medical information. That's just how it is.
Okay, next question. Can a landlord request to show the unit to potential buyers while the tenant stays in the unit?
Yes. It's my understanding, pursuant to state law, that one of the acceptable reasons for entering a unit is to show the unit to prospective buyers, and the tenant may or may not be present in the unit while that happens.
Yeah, that's correct. And, I think just generally you should try to work with the tenants as much as possible, because although, landlords have this right under this state law, there are also competing rights from the tenant's perspective as well. So for example, they have a implied covenant of quiet enjoyment, which is applied to every California residential lease. And so they are, free, they're supposed to be free from unreasonable disturbances and, kind of noises, that kind of thing, and harassment. And also there's rights to privacy in your own home. I think in the context of a landlord-tenant, perspective, the implied covenant of quiet enjoyment, which I believe Paige talked about earlier in the presentation, I think that's a stronger argument for the tenant. However, it's very fact specific, right? I mean, you have two parties that have rights, and the question is always, where is that line? And it really just does depend on the facts. But generally speaking, yes, Paige was correct that you can issue a notice. If you want to show the unit, that's totally fine. Give that proper notice, make sure that you tell the reason, what time you're coming in, and keep a copy for your own records.
Okay. Next question is, if you're changing or hiring a property manager, can the property manager schedule a visit with the current tenant to inspect property for the new property management agreement to manage the unit?
To inspect for what?
Can the property manager schedule a visit with the current tenant to inspect the property with the new property management?
Oh, okay. So any inspection, any entry, as kind of what Paige discussed pursuant to California Civil Code 1954, it has to comply with that law. And so if there's a reason within that law that you can find to enter, then yes. But you cannot create your own reason, right? Even if you write it in the lease, for example. So I've seen it where landlords have written in leases, landlord, may inspect every 3 months. Just inspect, kind of general. And that's an unenforceable provision. You cannot enforce an illegal provision that you just kind of threw in the lease, even if it's written in the lease and the tenant signed it and all that. It doesn't matter. If it doesn't comply with the law, you cannot enforce it.
Okay. And I believe, okay, so the next question is, I'm working with a management company and they took my security deposit. When I asked for copies of proof of costs over $125, they just ignored both of the letters I sent. I also asked for their agent a process to sue them and got nothing back. Is there anything that I can do?
I think yes. So if you have and I'm going to answer this from the tenant's perspective. If as a tenant you have not been returned your security deposit within the 21 days, you can go to small claims court to request that that be paid back, and you can actually receive, I believe, Palomar will correct me, but I believe it's treble damages. So if the landlord or property manager has improperly withheld the security deposit beyond the 21 days, you can move forward with taking them to small claims court to get that money back.
Yeah, that's correct. The Civil Code that Paige mentioned earlier, the California Civil Code 1950.5, has a provision in there that says, well, if a tenant alleges bad faith on the part of the landlord when they deducted that money, then they can claim 2 times the amount of the deposit in addition to the deposit itself. So it is a triple damages clause. Whenever you allege bad faith, it's on the part of the tenant to prove that. It's a burden shifting analysis. So the burden is initially on the tenant to prove bad faith, and then it can be rebutted by obviously by the landlord to say why not. And I think generally speaking, at least what I've seen, judges tend to not grant bad faith unless it's pretty egregious. But that said, it gives a bit of more leverage to a tenant because, let's just say the deposit was $3,000. Well, if the tenant's saying bad faith, that's now $9,000. And so it gives a little bit more kind of negotiation power to the tenant, because most of these times these cases end up settling. And so their settlement kind of negotiation power is higher because they actually allege far more than they really lost. So it's kind of supposed to be, I think, a deterrent to landlords to, not kind of follow the law. They're supposed to give that documentation. They're supposed to give an itemized list, do it within 21 days. And failure to do any of these things kind of adds to the argument that the landlord has acted in bad faith.
Thanks,
Okay.
Palomar.
The next question, I think there needs some clarification on the OMI process, and it looks like they have some statements along with it. So the question is, I didn't get a clear answer. So when can we answer the question again? The owner move-in process started February 16th, and the tenant was supposed to be out by April 25th, and all the paperwork is up to date with the rent board. So what is my next step? Unlawful detainer, or what do I do from this point?
So if the notice has been given, and it sounds like the notice ran, it says I think it said it was given in February, is that right?
Yeah, it was served, sounds like it was served February 16th.
Mm-hmm.
Okay, so that means that the notice would run after this, I think, this order was passed. So if that's true, then you can't do anything until the order expires. But once the order expires, let's just say that it did expire or it does expire on September 30th, then yes, you could in theory move forward with that. And that's what you would do after any notice, any termination notice. And this is just generally, the next step is filing an unlawful detainer. That's how you do it. It's notice, unlawful detainer, and then judgment. And that's kind of where you move. That's kind of in a nutshell. So, that's, unfortunately, you just kind of have to wait. The problem is that this pandemic has affected not only, Contra Costa County, Richmond, the courts. I mean, there's so many things. So, but, at the same time, the city council may extend it further. I mean, this pandemic is raging pretty strong in California still. So, I don't know what they're going to do for sure, but my guess is it may be further extended. So you just kind of got to wait and see. But I would use this time to speak to legal counsel. That's the good use of this time, because you can do your due diligence, set expectations, understand the process, talk to an attorney about like what your options are, how is this going to work. All of these questions are best directed to your legal counsel. I mean, I cannot emphasize that enough.
But generally, Palomar, if they wanted to initiate, I mean, let's say this wasn't happening during the pandemic, and I'm not sure to what extent the self-help legal website is up and has all the information, but a landlord could access unlawful detainer paperwork through the self-help court website. So you'd have to go to the California Superior Court, the Richmond courthouse, and obtain that documentation and fill it out and file it.
Yes, that's correct. Every person can, in theory, file a lawsuit, right? I mean, you don't have to be a lawyer, but, in my opinion, I think landlord-tenant law and specifically unlawful detainers are very complicated. The reason is that they generally move very fast. I mean, like a civil lawsuit in general would be, I don't know, depends on the case, but it could be like anywhere from 6 months to a couple years even, or something. It can vary. But an unlawful detainer, that's like a few months, maybe. It's like very, very fast compared to other types of lawsuits, which is why if you miss a deadline, that's it. Like you're out and you got to start all over again. And so, it's very complicated, even for attorneys who are trained in this to, kind of do these lawsuits. And so, yes, in theory, a landlord could do it themselves, pro per, represent themselves, but it's not, the recommended way, because you could spend all that time, all that money trying to do it. You miss one deadline or you miss one filing or something, and that's it. Your case is over.
Okay, thank you for that. Next question is, can a tenant insist their presence when the landlord needs to enter the unit for repairs, especially now due to COVID?
So it's my understanding, based on the landlord lawful entry civil code, that the tenant cannot demand that they be present when the inspection is taking place. Now, I think it is really important in these times to work with the tenant, especially during COVID. They may have certain concerns around a landlord accessing the unit, and to avoid conflict, just asking about what their concerns are. If there's personal protective equipment that someone who needs to inspect the unit or complete a repair is wearing, I would recommend working with the tenants to try to figure out a solution that works for everyone. But in general, I'm not aware of anything in the civil code that says that a tenant can demand that they be present while an inspection or a site visit takes place. That said, I don't know if there are specific protections given COVID that would allow a tenant to deny entry if there's a concern around the pandemic.
Yeah, I agree. I think they can be there. I mean, the tenant can choose to be present, right? I mean, they can't say, like Trade said, they can't demand that only it happens when they're there. That's true, but of course, the tenant can be present if they want to be. There's no, but the thing is, because you said about work, and so there is a possibility that the work cannot be performed while that tenant is there. Like, say they have to do all kinds of construction. And that could lead to one of the just causes, which is a temporary eviction to undertake substantial repairs. I actually had a question about this, I think, yesterday. And so, it's the tenants can say, well, I need this done. And then the landlord's like, well, I need you to leave because it's not safe or something like that. And then that would trigger the relocation ordinance. You'd have to pay them a temporary, whatever days that they're out of the unit in order to perform that work. And so there are potentially certain circumstances where, the tenant cannot just physically be there because it's just unsafe. So I get that kind of perspective. I'm not sure what this person was asking when they wrote that question down, but they could, if it's safe, then yes, they could be there. And if it's not, and the landlord's like, you can't be here, they should try to work together. But if they can't work together, then a landlord could, in theory, issue a notice for temporarily to vacate to do substantial repairs. Now, the other added caveat is that right now, those are actually prohibited because that's considered a no-fault eviction. And so, along with Ellis Act and owner move-ins, temporary eviction to undertake substantial repairs are one of the no-fault just causes that are actually currently prohibited. So, to force that type of move out or to get the tenant out is actually, you can't do it right now.
I would add though, Palomar, I think, and you can correct me if I'm wrong, but if the repairs are needed for health and safety, like if it's an urgent health and safety issue, then they may still be able to conduct it. But again, I think we would say consult with legal counsel on that one for sure.
Correct. Yeah, yeah, exactly. Like, again, I mean, the emphasis on talking to legal counsel during these complicated times is like really, really important.
Great, thank you, guys. Next question is, how often can you inspect a rental by law?
I'll take that page. It doesn't really say how many times. All right, there's no number. Laws generally don't like to do that because it's very kind of fact specific. But you know, you have to have a reason under the law, right? If you have a reason and it's permitted under law and you provide proper notice, then you can enter. However, like I said earlier, there's every tenant in California has a right in their lease. It's called the implied covenant of quiet enjoyment. And so even, let's just say a landlord gave a notice under the law every day and came in every day. I mean, they're legally doing it, right? Possibly. But there comes a point where it's just disrupting the tenant's life so much that you're really kind of breaching the lease agreement, because this implied promise, as I said before, is in the lease, no matter what, even if it's not written in the lease. And so you cannot violate, no landlord can violate the implied covenant of quiet enjoyment. Now, where that line is, I don't know. That's very fact specific. But you know, it's very possible to violate that if it's a harassment issue. So.
Okay, and this one is a follow-up to the OMI case question that we answered earlier. It sounds like they inherited the house from their parents from their passing, and they feel that it's unfair to them because they had already given the tenants the first half of the relocation payment.
Yeah, so this is a tough one. I think that folks who started a process and then it's been, you know, the pandemic has interjected that process can really put folks in a difficult situation. And all I can say, besides, you know, wanting to just say that I feel for your situation and it sounds really difficult, is that, you know, you have already paid that first half. So that's already been given to them, and the second half isn't due until they've actually vacated the unit. So again, as Palomar mentioned, you know, if once the order is lifted, which could be as soon as September 30th, you can move forward with the rest of the process. And if there is, you know, if the tenants do not move out voluntarily, then you would need to go through the unlawful detainer process.
Yep. And there is a part of the ordinance that speaks about the return, like if you pay the half and then they don't move out, and that's how they're supposed to return it. So there is a process. There is kind of some stuff under the law that it requires the tenant to do, namely to give the money back, and also to give an accounting of any expenditures, and also name any third parties that they paid to, you know, that kind of stuff, so you can get that, recoup that money. But if you have questions about this particular issue, you should definitely call us or email us so we can have a chat. I'm actually one of the people who do a lot of the calls and emails, so I would love to speak to you if you want. And otherwise, you can always talk to legal counsel, like I've been saying.
Right now, we don't have any questions, so we can just wait a few minutes and see if any pop up.
Sounds good. We'll give it until 11:30. Well, if there aren't any other questions, I want to thank everyone for joining us this morning. And again, we do have counselors available. Oh, it looks like we have a couple more.
Yeah, one question. Okay, just in time. Okay, so the first question says, let's see. I guess this is a repeating question. What I asked before about the agent of process not being given when asked for, is this illegal for them to do? Not sure what the word
So it sounds like they asked for who is the agent for service of process. Is that correct? I think that's
what it sounds like. Yeah.
Yeah. I mean, I don't know about it being illegal. You know, it depends on, so service process of service one can be a bit tricky. Service of process, that's what I mean. One, if the owner or whoever you're trying to serve is a company, then they're likely registered with the Secretary of State of California, and you can always look up any corporation, partnership, business on that website, and they will always have a registered agent for service of process there. Now, if it's a regular person, then you can either serve them, you know, at their residence or at their principal place of business. But you know, service of process does have some kind of how do I say it differing dates, meaning that if you give what's called substituted service, which means that you serve someone else who like lives in the house, who's an adult, then it actually, you need more additional time to like process it. And anyway, so it gets a little complicated, but that said, agents for service of process can be found on the Secretary of State website. And if not, then you can always serve them either one at their principal place of residence or their principal place of business.
Okay, great. Next question is, can a tenant break their lease midterm? If so, do they owe the landlord any penalties?
So that's a good question. First of all, any tenant can break a lease. I mean, it's, you know, it's a contract, not a prison sentence. So they can, of course, break the lease if they want. The analysis for breaking a lease is not so simple. It's any allegation that a breach of lease has occurred, you must follow California Civil Code 1951.2. And essentially, this law says that a landlord has to make a reasonable effort to re-rent the premises in order to continue to charge rent. So let's just say a tenant breaks their lease 6 months into a 1-year lease. The landlord can't say, oh, well, now you owe me the rest of the money for this lease. That's not true. The law says that you're supposed to mitigate your damages by making a reasonable effort to re-rent. So once you are informed that the tenant is or has vacated, then it's an affirmative obligation on the landlord to actually try to re-rent. Now, it says reasonable effort, so I think that's pretty minimal, you know, putting it out on Craigslist or something like that. Now, from the time that you put it out there and you're making that effort to the time that you find a replacement tenant, that's the time that the tenant who broke the lease, that's what they'd be liable for. But that's it. Once that, it's just that time when there was no sitting tenant. Once the new tenant comes in, you cannot double dip. Under California Civil Code 1950, it says you cannot charge 2 tenants for the same space at the same time. You know, one who doesn't live there and one who does. So that's kind of how it works.
Next question is, will the new state bill, AB 3088, prevent the city council from extending the eviction moratorium?
I'm not too familiar. Maybe Paige, you might be familiar with this. I'm not familiar with that particular assembly bill. You know, yeah, state laws can have an effect, but in this current period, back in March, the governor gave local jurisdictions the authority to pass this type of legislation. And so it's not like the state can pass something and then all of a sudden all these local laws that they pass are just ineffective. That's not true. The local law, like Richmond or Contra Costa County or something, they have the authority to pass these regulations, these orders, that kind of thing, without state intervention. And so, you know, I can't say whether or not, because again, I don't know what that AB law is, but it really just depends. But in most cases, in all likelihood, a new state law is not going to have a chilling or kind of termination effect on a local order that's been passed to the pandemic.
And that is the COVID Tenant Relief Act, AB 3088, and to my knowledge, it hasn't yet been adopted. It's in the process. So any updates that we have will be posted on our website regarding how a state law affects the local law. So I apologize that we don't have a full analysis ready since the law has not yet been passed, but once we do, we'll be sure to update the community on our website.
Okay. Next question is, how can I find a good eviction attorney? I looked at Yelp and the upfront retainer is about $2,000. Does that sound reasonable?
It's a good question. I can't say what is reasonable in terms of price. Every attorney and law firm may be different. What I will say, what I usually tell people who are looking for an attorney is that a good attorney, one, will always get back to you within 1 to 2 business days. If you call and request to speak to someone and you don't get a call back for 5 days or something, it's probably not a good call. It's probably not good professional business. But just putting that aside for a second, you also just want to see what their experience is, what their win rate is, not win rate, but win record, I guess. Usually law firms have like a bunch of we settled for this and we won this case and we tried this. They have it on their website to kind of boost up their, how good their firm works. But the main thing is that you want to have a simple conversation with someone, an attorney, and talk about your case. And now, if from that conversation, if you have a good sense that they know what they're talking about, that they have direction, that they're respectful, and that you can work with them, and you have a good gut feeling about this, working with this attorney, then do it. I wouldn't take the first attorney that you just talked to. Of course, you can always call around, see who's available, what's possible. And most attorneys should really just, not charge you for the first conversation. They should just have a talk, But again, like I said, each attorney and each law firm is different. And so you could have a $2,000 retainer. I've seen for much more. I mean, it really just depends on that firm. So.
Okay. Next question is, what issues does the owner have when selling the rental property? Or maybe what should they consider when renting the rental property?
So we typically recommend that when you are selling a rental property or completing that kind of transaction, that you call us to talk about any questions or issues that you have. In general, again, as I mentioned, that the selling of a property is not a just cause for eviction. So that would be something important to emphasize. Notices that are issued to the tenant, notifying them that the property is up for sale, cannot, require the tenants to move out. Wanting to show the units to prospective buyers is allowable under the Landlord Lawful Entry Civil Code. But again, the tenants may or may not view the units while you're doing showings. And I'm not sure how the pandemic and concerns around COVID would affect all of that. So that's something that you may want to talk to realtors and legal counsel about. What a lot of landlords will end up doing are selling the properties with the tenants in them. And then you would need to transfer the security deposit to the new owner or return the security deposit to the tenants. And another important consideration is to make sure that the tenants know where to send the next month's rent once the property has transferred. So making sure that you communicate with the tenants to make sure that they understand where they should send the rent moving forward once the property has sold. And Palomar, do you have any other thoughts on that?
Well, I just actually wanted to add to that point about like inspections and entry during this pandemic. There is some guidance from the Contra Costa County Health Department. They have issued their, I forget what they call it. I guess it's the shelter in place order, SIP. And in there, they list out essential businesses. And one of the essential businesses is people who carry out residential transactions. So people selling or renting property, landlords, you know, managers, that kind of thing. But it does say that any entry, you cannot enter while the tenant is there, or the occupant is present. I guess that's what it says. It says that any inspections or showings must be done virtually, not inspections, showings. And if they can't be done virtually, then it's basically by appointment, because you have to coordinate with the tenant so that they're not there. And you can only come in with 2 people who are from the same household in addition to the person showing the unit. So it's like if it's a realtor and 2 people from the same household, then you can enter. But if the tenant is there, then you cannot. So it does require a little bit of, you know, coordination with the tenant because of these kind of rule changes according to the county health department. That was all I had.
Thank you. Thank you. Next question is, what is the status of the proposal to allow tenants the first right of refusal to purchase their unit if the landlord decides to sell?
To my knowledge, this proposal has not been further contemplated by the City Council. I don't believe anything's been adopted this time.
Okay, that's the last question we have right now. I don't know if we want to wait a few minutes.
Sure.
Okay, one more question. Okay, so we are in contract to purchase a Section 8 single-family home for our primary resident. Does it also need a 60-day notice?
Yeah, so whenever you're dealing with Section 8, what's going to be required is that you're going to need to deal simultaneously with the rent program to make sure that, in this case, I'm assuming that you're saying you would do an owner move and eviction once you purchase the property. So you'll need to be in touch with us about how to do that process and accessing resources on our website, but you'll also want to contact the Housing Authority of Contra Costa to make sure that you're also satisfying all of their requirements, because the HAP contract that the tenant has with the landlord has specific requirements around good cause for eviction. So that is something that you should absolutely look into. So in terms of needing to provide 60 days notice, and Palomar, has that been changed to 90 days?
90 days is for rent increases.
Oh, okay, right. So there would need to be 60 days notice for termination of tenancy if the tenants have lived there for a year or more. But the Housing Authority of Contra Costa and the Section 8 process may require something different. So there are essentially multiple layers of requirements that you're going to be subject to. Based on our requirements with the rent ordinance, it's a 60-day notice.
And plus, keep in mind the current order as well, as that applies to Section 8 tenants, which prohibits any owner move-in currently until the Richmond emergency moratorium on evictions expires.
Correct.
Great, thank you. Next question is, what happens if 2 tenants sign a lease, but one tenant dies? Does the remaining tenant still retain their full rights to the unit?
Yes.
And the tenant may be able to get a replacement roommate.
That's right.
Okay, that's that last question. We have one more. Let's see. Does new owner move-in also restrict for 3 years before using it as a rental?
So the current requirements as provided in the rent ordinance around owner move-in state that the owner or relative that moves in should plan to reside in the property for 36 consecutive months. Otherwise, it could be seen as an owner move-in that was conducted in bad faith, and the tenant who was displaced could use that as an argument to show that the landlord did not, was going through with the owner move-in process in order to evict to be able to re-rent. So I would say with that, proceed with caution. You may put yourself at a liability if you don't adhere to the requirements of the rent ordinance.
That's right. And the liability would likely come in the form of a private right of action from the tenant. Tenants who are displaced wrongfully because the landlord said, oh, I'm going to do an owner move-in, please leave. And then they leave and then they just re-rent it out. That's called a wrongful eviction. And the tenant would then have a private right of action to sue the landlord for, not only whatever money that they were owed, out-of-pocket costs, possibly attorney's fees, mental and emotional injury. I mean, there's quite a lot. And so those lawsuits are there, hopefully to deter landlords from doing any type of wrongful or constructive eviction.
Great, thank you. There's no questions right now, so wait a couple minutes.
So I see the question that popped up, if the new owner lives more than 1 year. I'm not sure what the question is. Again, the rent ordinance requires that the owner or relative live there for 3 years.
Thanks, Paige.
Mm-hmm. So seeing no other questions, again, I want to thank everyone for joining us this morning. And if you have questions that come up after you leave today, please feel free to send us an email at rent@ci.richmond.ca.us or give us a call at 510-234-RENT-7368. And we'll look forward to continuing the conversation. So thanks again for taking time out of your day to attend this presentation. We really appreciate everyone taking the time to become educated about their rights and responsibilities. And we hope you have a great rest of your day.
Thank you, everybody.
Thank you, everyone. Thank you.
Everyone.